Now you will see the reason Ozokome and Ifeanyi Ejiofor was sacked. And before we go there, let us just come across the
By the judgment of the Court of Appeal that ordered the federal government to release the leader of the indigenous people of Biafra IPOB, Mr. Nnamdi Kanu, from detention. The Supreme Court ordered the continuation of the trial bordering on terrorism preferred against Mr. Kanu. And in a unanimous judgment prepared by Justice Garba Mohammed but read by Justice Emmanuel Agim, the 5-member panel of justices say the federal government acted, in their words, irresponsibly when it forcefully brought Kanu back to the country from Kenya against all known laws. However, the Apex Court held that it was not enough to divest the trial court of its jurisdiction to continue with the case. Let's take a listen to the counsels.
We had hoped that it would come our way, but it has gone the other way. It simply means that we have to go back to the High Court and get done with this quickly. We still have hope. We're not in despair.
By the grace of God,
yes. So
victory is assured.
Yes, we
at the
will.
end of the day.
We will lose a little time. We still have to go back. That's all it means. But I'm very consoled by what the Supreme Court said, that he ought not to have been treated the way he was treated. His bail ought not to have been revoked. His home ought to have been invaded. All that is a consolation to us. So we have hope.
This is victory to our administration of criminal justice, because it shows that once you are an accused person, once you are a defendant, no matter what excuse you want to bring to hide under the law to say that you should not be tried, the Supreme Court have expressly, unequivocally stated clearly that
and I think by
we don't have the legislation that will vitiate the court from trying a defendant that has committed a crime. You must be tried for every offense you have committed. You saw that the court came very heavy on the security agencies, where they have in any way, impaired on the rights, the fundamental rights of the defendant. However, our laws have made very clear provision for remedy. Where there's such infraction on the right of the defendant, then you can such a defendant can go to the civil court and then seek for civil remedies for the violation of his fundamental rights. And that is why, of course, we have the fundamental rights enforcement.
Now, the councils were not the only one.
Yes. So, lovely Biafrans, before we enter this place now, Mazen Nnamdi Kanu, when he was teaching, when he want to give critical teachings, he will say, I invite you to come and listen to this teaching, the gospel of the day. But if you are, hey, what is this? Is this super chat? Oguro, Sunday. Is this super chat? This is 1,000 naira. Okay. Thank you so much. Per character holding his belly, laughing. Okay, thank you. Okay, my brother, thank you so much. Biafrans, a lot of super chat is falling in this place. A lot is falling in this place because Biafrans are enjoying what we are doing. They said, we promise that we will bring Biafra from diaspora. Through internet, we tell them that they are right. Self-defense is your right. Under self-defense law, that is why I am talking. But let us continue in this place. This our brother, Ogro Sunday, John. Mechuko Kabiama, bless you so much. Refill your pockets, give you a long life and the prosperity. And the reward he will give you is that you and your children and the generation will enjoy the freedom of Biafra. That is what we can do for now. Udo, what is that? Okay. Before we continue, Biafrans, listen on how we play, how PM destroyed this people. We don't close the door, please. Close the door. Then, listen, we go here first.
A proper Biafran lobby in Washington, D.C., the Prime Minister has delivered his master stroke. And if you can look at the Nigerian media and the social media, you will see that this is something that's been highly publicized.
Program. I say, God, give me
stroke. And has made remarkable progress and has outsmarted the Nigerian system. And the minister has made remarkable progress and has outsmarted the Nigerian.
The Prime Minister has outsmarted Nigeria. That is what I want to bring out in this place. And Biafrans, I want us to now take the dose of your common sense, just like our leader used to say. Take the dose of your common sense, then you will be able to see the reason Ifeanyi Ejiofor was sacked, Ozekome was sacked, and the reason, if you hear the early interview in this place, they said they are blaming themselves. And the reason they cannot rendition our PM is the process they have to undergo. And they are blaming themselves. Today, 50 lawmakers already signed. They say they are doing this thing to help Nigeria, to clean the shame upon Nigeria. That is why all the lawyers is signing for Nnamdi Kanu to come out. And then Nnamdi Kanu is coming out with this. Something we have to tell you now, which is very, very awaiting to every Biafra, is this. There is something our Prime Minister said when he was doing analysis. He said that Ojukwu had the opportunity to address United Nations. But when he found out that he has nobody on his side again, Owazurike withdrew. Who did I mention? When PM was analyzing, he made us to know that Owazurike had the opportunity to address United Nations under Biafra freedom. But Owazurike found out that this game they used DOS to play against against our leader Mazen Nnamdi Kanu is what they played on him. He found out that he has no soldiers again. And for this reason, we stand very, very strong to our Prime Minister, who came to fight for Biafra only to make history. The thing, if you are following our PM, the only thing you see our PM having sleepless night today is just because he wants to make history. He wants his name to be in front of page, nothing more. And for this reason, today, our PM already have that opportunity he is looking for. Tomorrow, State of the Nation address, we will then come out with the other packages we have. But PM is not going to mess up, because if Nnamdi Kanu come out, any which way he come out, he is going to join the bridge. Hey, let me not go too much, but here you will see how Ejiofor and the Ezekome was destroyed. Let us continue.
Continuation of the trial bordering on terrorism preferred against Mr. Kanu. In a unanimous judgment prepared by Justice Garba Mohammed but read by Justice Emmanuel Agim, the 5-member panel of justices say the federal government acted, in their words, irresponsibly when it forcefully brought Kanu back to the country from Kenya against all known laws. However, the Apex Court held that it was not enough to divest the trial court of its jurisdiction to continue with the case. Let's take a listen to the counsels.
We had hoped that it would come our way, but it has gone the other way.
They hope the matter will go their way, but it has come the other way. Let's continue.
It simply means that we have to go back to the High Court and get done with this quickly. We still have hope. We're not in despair.
By the grace of God,
yes, so
victory is assured.
Yes, we will. We will lose a little time. We still have to go back. That's all it means. But I'm very consoled by what the Supreme Court said, that he ought not to have been treated the way he was treated. His bail ought not to have been revoked. His home ought to have been invaded. All that is a consolation to us. So we have hope.
This is victory to our administration of criminal justice, because it shows that once you are an accused person, once you are a defendant, no matter what is...
Please, dear friends, what you will be, at least you know you have to take the dose of your common sense before you will be able to be following. There is a popular song we used to sing in this Biafran struggle. Gowana mara akwụkwọ kpọba Colonel n'ọdara iwu ndị amị anyeye. These are the people that want to jail Mazen Nnamdi Kanu. And here they are regretting, and they are here blaming themselves in front of the public. Mazen Nnamdi Kanu say, "Okwa aga aka, ogosigo ebe gada." And the PM, with more than 1,000 men wisdom God gave to him, he outsmarted them. You see how lobby in a White House is happy to work with him. That is what you have to understand. They said he outsmarted Nigeria with more than 1,000 miles. Let us then go there. Take the dose of your common sense. Then we go.
Excuse you want to bring to hide under the law to say that you should not be tried. The Supreme Court have expressly, unequivocally stated clearly that we don't have the legislation that will vitiate the court from trying a defendant that has committed a crime. You must be tried for every offense you have committed. You saw that the court came very heavy on the security agencies where they have in any way, impaired on the rights, the fundamental rights of the defendant. However, our laws have made very clear provision for remedy where there's such infraction on the right of the defendant. Then you can, such a defendant can go to the civil court and then seek for civil remedies for the violation of his fundamental rights. And that is why, of course, we have the fundamental rights enforcement.
Now, the councils were not the only ones that reacted to that judgment. The governor of Anambra State, Chukwuma Soludo, also says he respects the rule of law, but believes a political solution could also be considered in this particular case.
I am a governor who believes in the rule of law. And in the country today, when the Supreme Court speaks, that's final. And the Supreme Court, in its wisdom and judgment, considered that he should go for a fresh trial. We can only say, we don't question that, we don't challenge that, we'll just say the rule of law will prevail. And I think that will go through its judicial process. For me personally, and as everyone knows, that I've been aware of the judicial process. But in spite of that, I have persistently and consistently called for a political solution to this issue.
So, dear friends, if you listen in this place, this is when Ejiofor accepted that our leader has to accept another trial. When PM begin to shout and begin to cry, begin to shake everywhere, and he begin to put 6 days sit at home, 4 days sit at home, 1 week sit at home, everywhere begin to shake, because Ejiofor and the Ozokome already accepted that our leader, the case in which he has already won, must be revised. Before Aloy Ejimako then take over, what we are doing in this place now is to show you there is somebody that is writing something. I don't know. He's a China something. So I don't know the area you are standing. So Ludo, go and sit down. And no. Woman, listen to what we are doing in this place. The reason and how Ejiofor and the Uzokome lost the game. And the Soludo is the person that gave them the ideology of political solution and the command and control. You remember, it was Anambra State election that was on board before our leader was kidnapped in Kenya. Immediately that time, they imposed political solution. The person who brought the idea of political solution is this man you are looking in this place, Soludo. Then when PM say, no, this will not work because of his smartness, then they brought out another law that is called command and control. Are you getting it? So if you are here, join us. This is a past story, but it's good to bring it to the public how it is done. Be you in mind today that more than 50 judges are trying to clean shame in that name called Nigeria. That is why they are signing to clean the shame of Nigerian people. So we continue. We go.
Now, there's a lot to talk about when it comes to this particular case between the leader of the proscribed IPOB, Nnamdi Kanu, and the federal government. I'm going to introduce my guests, two senior advocates of Nigeria, in a moment. But let's walk you through some very simplistic way on how we got here in the first place. So first, Nnamdi Kanu was rearrested in Kenya and extradited to Nigeria by the federal government in June 2021. Now, he was arraigned at the Federal High Court Abuja before Justice Binta Nyako on an initial 4-count charge of treasonable felony, conspiracy to commit treasonable felony, terrorism, illegal importation of radio equipment, and defamation of the character of former President Muhammadu Buhari. Now, the charges were later amended to a 15-count charge on terrorism and membership of the proscribed group. Justice Binta Nyako at the trial court had in her ruling dismissed 8 out of the 15 charges, saying that Mr. Kanu had questions to answer in the remaining 7 charges. Of course, Kanu was not pleased, filed an appeal on the remaining 7 charges at the Court of Appeal. The court agreed with Kanu and struck out the case, and by implication, is free to go. And the learned Silk will explain all of that. But the FG swiftly filed a stay of execution. Another panel of Court of Appeal Court justices sat and upheld FG's stay of execution. Now, the FG appealed to the Supreme Court on the quashed 7-count charge, insisting on continuation of trial at the Federal High Court. Today, the Supreme Court sat and agreed with the federal government that Kanu should go back to the Federal High Court to defend himself. However, the Apex Court frowned at how Kanu has been handled or treated by the federal government, but is at liberty to file a civil case against the federal government. So just a round-off or some kind of a sequence of how we got here in the first place. So my guest to explore all of these issues, Senior Advocate of Nigeria, right here with me in the Lagos studio, is Mr. Wahab Shitu. Thank you so much, sir, for coming on the program.
Thank you for inviting me.
And also joining us virtually is another Senior Advocate of Nigeria, Mr. Paul Ananaba. Mr. Paul Ananaba, thank you so much for coming on the program.
Thank you.
All right. Let's start with you, sir. I'm sure you're quite familiar with this case. And just a legal perspective of what transpired today at the Supreme Court.
Well, the Supreme Court has pronounced. And essentially, the pronouncement of the Supreme Court can be categorized into 3 main aspects. The first aspect of the pronouncement, which is decisive, is that Mr. Nnamdi Kanu is requested to go back and be arraigned on respect of the 7 counts, to go and face his trial in respect of the 7 counts earlier decided by the trial court. That's the first one. The second question, which is also very instructive, is to also say that the federal government can be, the way the federal government handled the deportation of Mr. Nnamdi Kanu outside the country to come and face the trial, offense against best practices, actually slammed the federal government for the way and manner it handled the deportation. And also caution that is likely to affect, that the federal government henceforth ought to be aware, ought to be sensitive about its image, locally and internationally. That's also a strong indictment. The third one is to say, the bail, that it was wrong of the trial court to have revoked the bail of Mr. Nnamdi Kanu following the invasion of his residence by law enforcement agents. So those are the three key aspects. But as it is now, what is significant about the pronouncement of the Supreme Court is that Mr. Nnamdi Kanu is now requested to go and face his trial. Now the question you want to now say is, okay, that is what the Supreme Court has decided. And once the Supreme Court has spoken, that's the final court. There's no appeal. You cannot appeal against the pronouncement of the Supreme Court. That's the law. And I must also say that the Supreme Court correctly interpreted the law, best practices, actually slammed the federal government for the way and manner it handled the deportation. And also cautioned that is likely to affect, that the federal government henceforth ought to be aware, ought to be sensitive about its image, locally and internationally. That's also a strong indictment. The third one is to say, the bail, that it was wrong of the trial court to have revoked the bail of Mr. Nnamdi Kanu following the invasion of his residence by law enforcement agents. So those are the three key aspects. But as it is now, what is significant about the pronouncement of the Supreme Court is that Mr. Nnamdi Kanu is now requested to go and face his trial. Now the question you want to now say is, okay, that is what the Supreme Court has decided. And once the Supreme Court has spoken, that's the final court.
So, please, it's like people is not really understanding what we are doing. People, we told you in this place, if you don't have the dose of your common sense, you will not understand this program. This program is how Ejimako, how Ifeanyi Ejiofor and Ozokome. Vale. Okay. This is how Ozokome and Ifeanyi and Ozokome and Ifeanyi Ejimako lost the case. This is exactly how they lost the case, because this man here now is telling you that Mazen Nnamdi Kanu has to then accept guilty. Ejiofor accepted that Nnamdi Kanu have to go back to trial before you see what is happening today. That is what we are telling you people. If you doesn't take the dose of your common sense, you will not understand what is happening. Tomorrow, our message will change, because tomorrow they will give us another subject to solve after the State of the Nation program tomorrow by PM. Another subject will come out, things we have to do, because there is win game. But the one you already won, try to understand how it goes. That is what we are bringing to you. That is what we are talking about now. This is how Ifeanyi Ejiofor and Ozokome was sacked because of our PM. Today, if not PM, Mazen Nnamdi Kanu, all those cases they charged against him, treasonable felony, everything will be revised back. That is what we are telling you. So from this, we are mobilizing ourselves for a new subject that is coming tomorrow. So we continue, please.
There's no appeal. You cannot appeal against the pronouncement of the Supreme Court. That's the law. And I must also say that the Supreme Court correctly interpreted the law. Because it's just like the analogy one can give to this is the issue of stolen evidence. If you steal evidence which is relevant in a court of competent jurisdiction. The fact that that evidence is stolen does not derogate from its admissibility. So you cannot say because the evidence was stolen, then it is not relevant. That's Section 14 of the Evidence Act. So as far as the law is concerned, the Supreme Court, the apex court, has correctly interpreted the law the way it should be interpreted. But the question that we should ask is that how do we deal with the Nnamdi Kanu situation? I'm in favor of a unified country. I'm in favor of a country that is united, a country that will. The Nnamdi Kanu situation must be handled very carefully. And this is a new regime. I'm in favor of taking a closer look, notwithstanding the case as pronounced by the Supreme Court. It's a very sensitive case. The governor of Anambra State mentioned the issue of adopting a political solution. I think that also should be on the table. Yeah. But I said you want to stop me here because I have some other, clarifications I want to make. But I can. But
on the case, right?
On the case.
Yes, but we're going to come to some of the things you're already speaking about. But I wanted to get the perspective of Mr. Paul Ananaba. Mr. Paul, I'm sure you've had the perspective of the learned Silk, your colleague, on this particular issue. I don't know what your interpretation or your perspective is as far as what transpired at the Apex Court is concerned today.
All right, thank you. Wahab Shitu, my brother, I greet you. I agree with Wahab Shitu largely to say that the Supreme Court is final, not because it is infallible. It is infallible because it is final. You have given a rundown of a run-off to where we are today. Really, the expectation of many Nigerians, it was clearly that Nnamdi Kanu will go home a free man today. So it is that may have thrown this to the front burner. And I go further to say that this case does not turn only on law. If it turns only on law, then it would have been a different thing if it was turning only on law. It is both law and security. It's so sensitive, particularly for those from the southeast and some other people who believe in the cause of Nnamdi Kanu. When you take that into the international law balance, you begin to talk about whether an act by a group that are asking for self-determination is a crime or not, even starting with the OAU Charter and down. So you see that in Africa, we begin to look at the jurisprudence of the fact that because we needed independence, then some of those acts will be considered not secession or treason or treasonable felony, but really self-determination. So what I want to draw from that is, yes, the Supreme Court has made the point that the decision that, yes, contrary to the decision of the Court of Appeal, that Nnamdi Kanu should face those 7 charges. Remember, the Court of Appeal has dismissed those charges. But the Supreme Court also made the point that the federal government was wrong in the way they handled this. Now, asking a person who has been in detention for all this while and whose detention is causing some discomfort to go back to a civil suit whilst in detention is of concern to me. I believe that the Supreme Court had all the powers, has inherent powers to take any decision in the best interest of the country. It's actually a policy court. So my expectation would have been, having found that the way the arrest was done wasn't approved by the Supreme Court, having found that the invasion of Nnamdi Kanu's residence and all that wasn't acceptable, I had expected that, yes, Nnamdi Kanu should stand his trial, but the Supreme Court also had the right and the powers to have granted him bail upon certain conditions. That way we de-escalate, because law is an instrument of social engineering and re-engineering. And I want to agree with Governor Soludo that perhaps it is now time, now the Supreme Court has spoken, that even revocation of the bail was wrong. If the Supreme Court had found that when the Supreme Court found that that bail was wrongly revoked, I believe that the Supreme Court would have made consequential orders, even in that respect, to say that that bail be restored. But Nnamdi Kanu will now be expected to go to court again to ask for restoration of bail. You see, the psychological content of law is important, so that a reasonable man will see that justice is not even delayed. I don't know how long it could take to file such applications. That's my concern. But the Supreme Court, I agree, was right in saying, okay, since we are set aside the portion of the 7 counts, go and defend this, the 7 counts before the Federal Court. But meanwhile, since your bail was wrongly revoked, your bail is restored on these conditions. Those are my perspective. However, the position of the Supreme Court remains the law and will continue to be the law.
So Biafrans, this is when they were contemplating to jail Mazen Nnamdi Kanu for life. And as we are coming up, when this news came up, this news now you are about to watch now, everybody stood up. PM is fighting from every angle. And this kind of news then begin to come.
That Nnamdi Kanu is being held hostage on behalf of the famed unity of Nigeria. That's what it's all about. It's as simple as that. If you mention his name in certain circles, they don't want to hear it because they feel like he threatens the real estate called Nigeria. Well, what you must know is that Nnamdi Kanu is being held hostage on behalf of the famed unity of Nigeria. That's what it's all about. It's as simple as that. If you mention his name in certain circles, they don't want to hear it because they feel like he threatens the real estate called Nigeria.
So we are bringing this news like this, recording everything we are recording. This China person, I can't even read your name. So if you don't like what we are doing, you go away from here. And our people is here. And if you don't think we are getting it right, you go and open up your own channel. From the 2023 Nnamdi Kanu came out. So however you want to do, we are bringing our news how we are bringing it because we are keeping record on how we are fighting.
And I urge that every Nigerian should respect the decision of the Supreme Court and follow through rule of law. All I've said is my expectations. But
all right, Mr. Ananaba, Mr. Ananaba, if I can butt in, so I can come back into the studio. I'll come back to you, Mr. Ananaba. Mr. Shitu, I was listening to some of the things he was saying, and then for those who are not legal minds like yourselves and who want to understand why, the reason why he appealed in the first place is because 8 was quashed and they sustained the other 7. And that same court is where it's going back to. They will be wondering psychologically, what will be his expectation from that particular court at the end of the day. I don't know whether I made that question as plain, as simplistic as I can.
This is not how the criminal justice system works.
Which is why you need to educate us.
When you are arraigned for a specific number of counts in a criminal trial process, in this case maybe 15 or 20 counts.
I must read this comment from Divine Precious. Divine Precious wrote, "Our leader extraction has made most of Biafrans become lawyers without going to school. You know, this is the same thing. There is we preach in this place that there is a way you will push a goat. A goat will push a goat to the wall. Then you will know that the goat used to bite. Then this is the reason Biafran Liberation Army got nervous. Nigeria become on fire. Nigeria begin to boom because justice has been denied to everyone. But one thing is this, that Ifeanyi Ejiofor and the Ozokome accepted this sentence for Mazen Nnamdi Kanu case to be renewed. And after this thing, they were sacked. Ifeanyi Ejiofor then take the lead. That is what we are telling you. Not only that we are doing Biafra and you see that Nnamdi Kanu is coming out. You will see that Nnamdi Kanu is coming out victoriously, because how is he coming out? He is coming out because choice of the people. The lawyers that is signing today, they say they want to cover the shame, and you hear it in this place. They say they want to cover the shame that is shaming Nigeria. Only that Nnamdi Kanu should come out. Then when he come out, he will go to Finland and tell our PM how and everything we play. And that area, we are not going there. We are here now.
And at the end of the trial process, I mean, after the prosecution has led its case, or you file an objection to the jurisdiction of the court to entertain the charges, if the court finds, based on the evidence or the proof of evidence, that some of the counts are sustainable, then you will say, do you have a case to answer? And those ones that are not sustainable,
messages is coming. Ifeanyi said, I remember when Mazen Nnamdi Kanu said, Buhari will give him Biafra. If this thing we are doing is in the hands of Goodluck Jonathan, nobody will be talking about Biafra. And at that time, Mazen Nnamdi Kanu said, if he stand up and begin to talk about Biafra when Goodluck was there, that Goodluck will answer to the call. But he say he will push Buhari, and the Buhari is the person who is giving him Biafra today. You understand? So Ifeanyi, thank you for that. So we continue, please. Let you understand.
The court will say, oh, you are discharged and acquitted in respect of those counts, which is what the court has said here. The fact that the court has said you have a case to answer is not conclusive of guilt.
Okay.
It's saying that, oh, come and offer explanations to clear some gray areas in order to be able to either prove your innocence or your guilt. So the window, that does not distract from the fair hearing, mindset of the trial court. And all lawyers know this fact. In a criminal trial, you have an option to allow the prosecution to call all its evidence, and at the end of the case, when it is your turn, you either elect to defend and meet the case of the prosecution, or you choose to make an application of no case. In which case, arguments will be taken in respect of your application on no case submission, and the court will give a ruling in respect of each of the counts, which is what the court has done here. 8 of them were dismissed, 7 of them were upheld. He felt dissatisfied and he appealed. The Court of Appeal agreed with him. But unfortunately, the Court of Appeal is not the final court. The state also appealed against the decision of the Court of Appeal. And the Supreme Court has today said, oh, go back and face your trial in respect of the 7-count charge. So what the Supreme Court has done is consistent with the law. Because, you know, the Supreme Court is a court of law, is a court of justice. It's also a policy court. At that level, all issues, the records, everything will be considered. And you can see that the Supreme Court examined all the issues and made pronouncement. They examined the question of his illegal, you know, deportation and pronounced that that is clearly offensive and that henceforth our country should be conscious of his image locally and internationally. That's a strong message coming from the Supreme Court. And secondly, when security agencies invade the premises of a suspect who is on bail, the trial court was not entitled to now revoke the bail after the man fled for his life. Again, that is a very strong statement. You know, so on all issues, the Supreme Court has done justice to the matter. You know, when somebody is alleged to have committed any offense, it remains an allegation.
Yes, sir.
He has the right to prove his innocence or guilt in a fair trial process. I think what we should advocate here are several options open to the federal government.
I was going to that because of time. So, because you have to look at it, this vis-a-vis the tension that has enveloped that region of the country where it comes.
So, what are we doing in this place? If you are a critical thinker, following whatever that is happening, China person, I don't know how to read your name. I am not from China, but what you have to know in this place, as a Nigerian government is making plan on how to rearrange and arrest jail Nnamdi Kanu, PM is planning something massive. Then he created Biafran government in exile. Then he created liaison offices, and everybody is booming up and down. Why can't you tell the people how everything played? You understand? This is the history, and we are not moving an inch than to make sure we gather the history, because if we can be able to be talking about the history of Jesus Christ since 2024 years ago, we have our own history to tell, and we are gathering all this history in this place. Remember that Jesus Christ was in court. Jesus Christ went to court before his crucifixion. How do you tell people what happened? This is what we are keeping on record, because Biafra is a religion, and Biafra is the last miracle on this very planet Earth. 50 lawmakers already signed, and more than 150 is in line to sign before ending of July. Are you understanding? This is mighty history that has never happened in the universe. Are you understanding? So if we are, you must give glory to whom honor due. That is what you must understand in this place. So we continue.
We have the issue of IPOB, sit at home and all of that. So with all of this decision, I want you to put in perspective, what is the way forward?
Well, the way forward is the rule of, one option is the rule of law option, which is to say, if somebody is alleged to have committed an offense, he should be allowed to go through the trial process, subject to the guarantee of his liberty. In this case, release him on bail, allow him to face his trial, but don't, while he's facing his trial, don't tamper with his liberty, subject to assurances that he will make himself available, and subject to assurances that he will not commit any further offense, alleged offenses. That's one option. The second option that government can look at, in the spirit of unifying the country, government may look at the exercise. You know, when somebody is alleged to have committed any offense, it remains an allegation.
Yes, sir.
He has the right to prove his innocence or guilt in a fair trial process. I think what we should advocate here are several options open to the federal
Yes,
government.
I was going to that
Yes.
because of time. So,
Yes.
because you have to look at it, this vis-a-vis the tension that has enveloped that region of the country where it comes from. We have the issue of IPOB, sit at home and all of that. So with all of this decision, I want you to put in perspective, what is the way forward?
Well, the way forward is the rule of, one option is the rule of law option, which is to say, if somebody is alleged to have committed an offense, he should be allowed to go through the trial process, subject to the guarantee of his liberty. In this case, release him on bail, allow him to face his trial, but don't, while he's facing his trial, don't tamper with his liberty, subject to assurances that he will make himself available and subject to assurances that he will not commit any further offense, alleged offenses. That's one option. The second option that government can look at, in the spirit of unifying the country, government may look at.
And this is the reason they are talking about this thing.
Well, what you must know is that Nnamdi Kanu is being held hostage on behalf of the famed unity of Nigeria. That's what it's all about. It's as simple as that. If you mention his name in certain circles, they don't want to hear it because they feel like he threatens the real estate called Nigeria. And his Igbo makes it worse because Nigeria's DNA hates the Igbo for attempting, in the 60s and, towards the end of the 70s, to leave a country they said is no longer favorable to their existence. But I keep saying, and I will repeat here again, is there any Nigerian out there in their majority who has not mentally seceded from, and I will repeat here again, is there any Nigerian out there in their majority who has not mentally seceded from Nigeria?
All this thing that is going on, these new lawyers now that pick this thing up, what this man said in this place, he says that they will release Nnamdi Kanu on bail, then he will be then coming to court. But Ejimako and the PM, government in exile, then say no, this will never work. Mazen Nnamdi Kanu has to go home unconditionally. And now the self-defense has to take effect because they want to use the jail of Mazen Nnamdi Kanu to legalize cows and they give cows Nigerian passport. Are you getting it now? To give the cows in Nigeria Nigerian passport, then PM is working very, very hard to make sure all those things didn't work. Now, when they see that the fire on the mountain is getting very, very high, now they have to accept. The lawyers, everybody should know what these lawmakers is doing. These lawmakers, what they are doing is what you have to know. They said they are running fast to make sure that a lot of lawmakers in Nigeria sign as more as possible, making sure that Mazen Nnamdi Kanu is being released under people's choice. So we continue.
The exercise of powers of the Attorney General under Section 174 of the Constitution that empowers the Attorney General to look at the case and decide whether in the overall public interest it is desirable either to continue the prosecution or discontinue the prosecution or enter a nolle, terminate the proceedings. The Attorney General can exercise that. But in exercising those powers, he has to have regard to public safety, public interest, paramount.
So are you saying, just so that before I go to Mr. Nanabai,
I'm saying that all options should be considered.
So what I wanted to ask is, what advice, in case the federal government comes forward, what advice will you, if you have the chance, to give to Nnamdi Kanu to in terms of the agreement you should come up with the federal government?
First of all, Nnamdi Kanu must, because federal government is concerned about terrorism. Every serious government, allegations body on terrorism is a serious allegation. He must be prepared to renounce all acts, or alleged acts of terrorism. He must give an undertaking. You must be ready to say, okay, you must also give an undertaking to make the peace.
Okay.
To ensure that, because peace is also very important to the federal government, because in the interest of the peace building process, federal government might want to engage elements who are close to Nnamdi Kanu, including governors from that region, to be able to see whether this matter can be amicably resolved in a manner that will not threaten the peace process, in a manner that will...
Do you hear what he said? That Mazen Nnamdi Kanu must renounce. He must renounce this flag. That is what is happening. And that is what Sowore said in that place. They are holding him hostage because they want to go. And here, our PM has to show something. We have to show it, and we must show it. That is what happened, and that is the story, how it goes.
Made remarkable progress and has outsmarted the Nigerian system in many ways. The Prime Minister has done this with the self-referendum. He has done this with opening diplomatic liaison offices around the world. And I think by establishing a proper Biafran lobby in Washington, D.C., the Prime Minister has delivered his master stroke. And if you can look at the Nigerian media and the social media, you will see that this is something that's been highly publicized.
Program. I say, God, give me 1,000 men wisdom. And you know what? God answered that prayer in abundance. So every problem that have come, God already positioned and put something how to handle it. In fact, I don't think that I have used up to 100 or 50 of those wisdoms, because the problem that is coming is very, all of them look very small. So as it stands now, Mazi Nnamdi Kanu is coming out. I have not even used 50 of the wisdom of 1,000 wisdom God gave me. Because, I am telling you, I have not used it. In fact, some of the problems solve itself without me even addressing it. For us, anything you did not hear from this platform doesn't exist until Mazi Nnamdi Kanu comes out. And when Mazi Nnamdi Kanu is going to come out, it will shock all of you. Yeah. And let me tell you one thing again. Do not think that Biafrans are fools. When you release Mazi Nnamdi Kanu, he must come to Finland. It's a condition. I will sit one-on-one with him. I have said this thing 2 years ago. They thought I was joking. He will come to Finland. The reason I'm fighting for him is that I supported him. I gave him a voice. I gave him a support and gave him the courage to continue doing what he was doing until he got kidnapped. You think I'm going to abandon him? You think I'm going to abandon Mazi Nnamdi Kanu? Even if he come today and say, Simon Ekpa, I don't know you. Simon, you think I'm going to abandon him? Because I know he can never say such thing under his normal, conscience. Because I contributed in supporting him, giving him the voice that you see him as a threat. You kidnap him. And then today, you want me to abandon him. I will not abandon him. Everything I'm doing today is geared at making sure that I demand his release. And if you do not release him, more calamity will befall Nigeria. Go and mark it somewhere. I'm not hiding my mouth. Calamity will befall Nigeria. And if you continue to be in Biafra land, planning how to kill our people with aircraft, with armor tank, you will all be neutralized. Except I am not fighting a just cause. Except I am not fighting a just cause. You should be ashamed of yourself that somebody is in Finland and that person is your problem. I wonder, why Mazi Nnamdi Kanu? I will be your end.
So, Iko Tonya Dezu, thank you. This is night. I have not used the 50 men wisdom, but out of 100 women wisdom. Are you understanding? we are over prepared in what we are doing. This is how they want to rejail the person who has already won all cases. So we play it until it's finished, please. No.
Ensure that further acts of terrorism in that region or anywhere are not, anticipated or perpetrated.
Good point. Let me come to you, Mr. Ananaba, as we begin to wrap up. This similar question I asked the Leonard Silk as well, just like you. We have to look at this broadly in terms of national security. If you were to advise both sides, both the federal government, he is giving some advice, both the federal government and Nnamdi Kanu and his team, what exactly would you be telling them just for us to have this national peace and move forward as a country?
Carlo, the Supreme Court has given a decision, and that is the final decision on that point. That is, you are still innocent. There are allegations against you. There are 7. Go and defend it. You had a bell.
Please, dear friends, if you are having joy, listen. Today, Ikotonia days didn't come early. Today, before you can understand our teaching this night, you must take the dose of your common sense. The reason Ifeanyi Ejiofor and the Yekome was sacked is this. Did you hear it here now? That Nnamdi Kanu is guilty before the fire begin to burn. Before the fire begin to burn. After they freed him, they want to jail him again. Ifeanyi Ejiofor, in front of us, he accepted. And you know, the last time when he went to court, he went there without paper. And he went there without pen. He went there and asked the judge, what do you do? How do you do? They say, okay, Nnamdi Kanu is guilty. They have to revise his case. He said, okay, no problem. And he came, he said, Umu Chineke, we are winning. Are you getting it? This is the story, how it happened. So we are keeping it. You must know how they fight the war. And the reason these lawmakers of Nigeria came up now, you must know this. This is what you have to know. Why they come up, and they make sure that they say the unity of Nigeria is in the hands of Mazen Nnamdi Kanu, no other person. So, but the game, because of the smartness of our leader, our prime minister, he said whenever he come out, he has to come to Finland and talk to him. Whatever they negotiate, you hear it here now, how they made the thing. Listen to it.
In terms of national security, if you were to advise both sides, both the federal government, he is giving some advice, both the federal government and Nnamdi Kanu and his team, what exactly would you be telling them just for us to have this national peace and move forward as a country?
Carlo, the Supreme Court has given a decision, and that is the final decision on that point. That is, you are still innocent. There are allegations against you. There are 7. Go and defend it. You had a bail. The judge revoked it. That revocation is wrong. Go back and take due process and ask for your bail. Supreme Court has already said that you are clearly more or less entitled to a bail. Get your bail, prepare your defense, and face up this charge. That is Nnamdi Kanu. For the federal government, I think that the country has so much concerns and worries that this matter ought to be looked at now after the pronouncements of the Supreme Court, showing that this has affected our image abroad, it has affected our image in Nigeria, invasion of property and fundamental